We'll start immediately by inviting the next bite-sized presenter. He is a practicing lawyer called to the Nigerian bar in 1999. He holds a doctorate degree in public policy and administration, specializing in terrorism, mediation, and peace from Walden, USA. And he has vast experience in litigating cases before all levels of courts in Nigeria. Let's give a resounding applause to Dr. Agada Elechi, please, as he comes forward to give us a bite-sized series on bullet points on the innovations in the new Arbitration and Mediation Act 2023. He'll be speaking to us for 5 minutes, which may be extended to 10 if he's captivating enough. Thank you, ladies and gentlemen. Dr. Agada Elechi, please.
Good afternoon, distinguished ladies and gentlemen. My task is to speak for 15 minutes. I've been told I should do it in 10 minutes. But if the learned seniors who are in front will give me the audience, I can start. Okay. My task is to talk about the notable innovations in the new Arbitration and Mediation Act 2023. For want of time, I'll just dive in immediately. Just to say that the very first thing to note about the new act is that it's now the Arbitration and Mediation Act, as against the Arbitration and Conciliation Act, which was there before. The second point to note, very quickly, the new act has mandated, via Section 5, that the courts, or rather has prescribed that the courts are mandated to stay proceedings once it's been brought to the notice of the court that there is an arbitration clause and that parties ought to have gone to arbitration rather than come to litigation. Prior to this, Section 4 and 5 gave the court some discretionary powers in this regard. That discretion has now been taken away by the new Section 5. Under the new act, we also have provisions for emergency proceedings and for the appointment of an emergency arbitrator as provided for by Section 16. So in this provision, essentially what it's saying is, if you have if there is a matter that has come up urgently that needs to be dealt with, an issue, you do not need to wait for the time it takes to constitute an arbitral tribunal. Sometimes it takes upwards of 6 months to constitute a tribunal. You are now allowed to go for an emergency arbitrator. Also, in the new act, we have provisions now, clear provisions for interim measures. As provided in Section 19, there was no such provision in the previous act. The new act also, via Section 39 and 40, make provision for consolidation and concurrent hearing of matters. However, this is subject to the approval and agreement of parties. Under the new act, there is, however, the powers for the tribunal to join parties. So there's now the provision for joinder. We didn't have that under the ACA. And the beauty of this provision is that the tribunal doesn't need the consent of the parties to join a third party in the proceedings. All that needs to be established is that that party is connected to the arbitration agreement or is covered by the arbitration agreement by implication. Also, under the new act, Section 54 provides for a lien on the award, the final award, in lieu of arbitrators' fees. Prior to this provision, it was a challenge for most of us practicing arbitrators to collect our fees. So if you've done the work and you are waiting for parties to pay the balance of your fees, if they don't, the trick then was not to say that the award was ready, because once you say the award is ready, you're under obligation to publish. So most arbitrators will not disclose that the award is ready. But now, you are allowed to write to the parties to say, well, your award is ready, but I'm going to hold on to it until I receive my fees. Then, also under the new act, another radical innovation is the change relating to the grounds for setting aside an arbitral award. Section 55 now provides very clear grounds on which you can apply to set aside an award, as against the initial provision which just had the issue of error on the face of the award or misconduct. So error on the face of the award or misconduct is no longer a provision. Then of course, again, another new innovation is as provided in section 56 as it relates to the Arbitration Review Tribunal. So under this new act, there is now opportunity for parties to agree at the point where they are entering an arbitration agreement to allow for an arbitration review tribunal to be constituted, sort of another tribunal which will act as sort of as an appellate body on the decision of the trial tribunal. Again, another innovation is the provision for third-party funding. So now, under the new act, third-party funding is allowed. And a further provision is as it relates to the arbitrator or appointing authority immunity. So there is now an immunity for the arbitrator or for the appointing authority with regards to their conduct in the process of arbitration. Prior to now, most of us practicing arbitrators would enter what we call a terms of engagement with the parties and incorporate in that a clause that says, thank you very much, a clause that says that you are immune from any prosecution. However, please note that this immunity will only inure in your favor if there is no bad faith on your part or no indication of bad faith. Another innovation is section 2 sub 4a, which now recognizes electronic communication between parties. Suffice to say that what this means is you can now enter an arbitration agreement or find yourself involved in an arbitration agreement, if you are not careful, by just communication. So those of us who use telephones, WhatsApp chat, and so on and so forth, you may inadvertently enter one without knowing that you are. In fact, recently, I think it was the High Court recently ruled that an emoji, a thumbs up emoji, is indicative of an acceptance in a contract. So you have to be careful. And then, of course, another innovation is as it relates to the number of arbitrators and indeed mediators. The default position now is 1 as against the previous 3. Then, of course, there are several provisions on mediation in the Act. All I have talked about previously were arbitration. The new, some provisions with regards to mediation have to do with the recognition of the Singapore Convention on Mediation as it relates to these settlement agreements reached via mediation and the enforcement of same. Also, there's provision now, which is for me a strange one, which allows the mediator. Yes, I'm almost done. Thank you very much. I'm rushing through. I know I have just a few minutes, but it's unfair to I've not even spent 10 minutes, Mr. Chairman. I'm timing myself. Thank you, sir. I've not even spent 10 minutes. Unless, of course, this is not interesting, then I can step away. Okay, so another provision is on section 73, sub 6. Yes, sir. Thank you very much, Mr. Chairman. Thank you. Another provision is section 73, sub 6, which now allows the mediator to make proposals for settlement to parties. Now, this is, in traditional mediation practice, this is totally unacceptable. However, the world is changing, and of course, we are also embracing evaluative mediation, so that provision now is there. And then, more importantly, and I think the one that interests me most, and I should bring to your attention, is the provision in section 75 that allows the mediator to disclose certain information. Again, this for me is worrisome because it goes against the spirit of confidentiality in mediation. Overall, I want to conclude by saying, I'm going to skip, I talked about the implications of the AMA on arbitration and mediation practice, but for want of time, I'll just go on to say that the Arbitration and Mediation Act in 2023 indeed marks the beginning of a new regime for arbitration and mediation practice in Nigeria. It presents with remarkable prospects and also daunting challenges. The effectiveness of the Act's innovations cannot be measured yet, as it is still yet to be tested. However, we are optimistic and we hope that sooner than later, it will be clearer that this new Act is a springboard to the needed advancement in arbitration and mediation practice in Nigeria. I thank you for your attention. Good afternoon.
Thank you very much. A warm round of applause for him. We go quickly into the next session, after which we break for lunch. Coordinators, please be on standby. May we call onto the stage the chair of that session, one of our past chair of the section, Olusegun Abimbola, Senior Advocate of Nigeria. The panelists, Dr. Yemi Johnson. Dr. Yemi Johnson, please. Dr. Damilola Adejumo. Please, a warm round of applause for them. Joyce Esseni, legal practitioner, and Lolu Osayin. Otumba Lolu Osayin, beg your pardon. The discussion would be around organ donation and transplantation under Nigerian law. It promises to be quite interesting, particularly in the light of recent events that all of us are aware of. I will hand over to the chair of session. Esteemed chair.
Thank you very much. We're going to breeze through this session, but it's important to underscore the importance of what we're about to discuss. The session is on the topic of organ donation and transplantation under Nigerian law. Distinguished panelists are lawyers, doctors, and I'm sure we'll have a good mix of medicine and the law. And I must thank our organizers, for particularly the Committee on Medicine and the Law, for putting this in the program. We have 4 speakers here who would approach the subject of discussion from various perspectives. And I'd like to be a little bit biased towards the doctors to give them 10 minutes to speak because we would like to get the full gist of organ donation and transplantation. And of course, the lawyers in our midst will have, well, I'll give you 10 minutes too, so that we can wrap this up in 40 minutes. And so I would like to call first to speak Dr. Damilola Adejumo. I think you're a doctor in the law, not of medicine, but you teach medicine and the law. And she will be sharing her thoughts with us with respect to the background on the basis for organ donation in relation, particularly when we look at our constitution that assures us, thank you, that assures us of the right to the dignity of the human person, and now you want to take out a part of that human person. So within those other perspectives, not just on the Constitution, but also on the National Health Act, perhaps you can share your thoughts with us in 10 minutes.
Yeah. Thank you very much, Leonard Silk. Let me just rest on the established protocol. We understand that a lot of us are already hungry. It's been a long day, so we'll try as much as possible to keep this as brief as possible. So if we're going to be talking about organ donation and transplant, most of the discussions I believe the panelists here will be speaking about will revolve around the issue of informed consent. And it is not surprising because informed consent is a thread that runs through the whole of the health law space. So in the context of organ donation, giving a background to what informed consent is about, we cannot but, of course, discuss the principle of autonomy of patients. And when we are talking about autonomy of patients, we are talking about the fact that your patient, a person that has come to your clinic, is regarded as having the right over their bodies. So autonomy simply means I own my body and I have the right to decide what goes on in my body. And even it's very interesting because even the medical practitioner cannot override the patient's autonomy. Even in situations where the medical practitioner believes that what he wants to do is in the best interest of that patient. So the principle of autonomy is very crucial and is one of the major pillars upon which the doctrine of informed consent is built. Now, relating this to the constitutional provisions, just like the chairman mentioned, we cannot be talking about informed consent if we're in the context of organ donation, if we're not relating it, first of all, to the right of self-determination, which is actually another name for autonomy in health law. Now, taking that to the provision of Section 34 of the Constitution, which talks about the right of every person to dignity. So in the context of organ donation, there is no way you want to deal with the body of a person without ensuring that you have the consent, or that person has given you the right to interfere with the inherent dignity of the person. So those are the background upon which informed consent is a very crucial thread in the web of organ donation. So now to the legal provisions. I'm trying as much as possible to keep my thoughts very concise. I made that promise at the beginning of this talk. So relating that to the extant laws in Nigeria, of course, primarily before 2014, there was actually no legal provisions regulating the medical profession. But in 2014, those of us in the health law space were very excited with the passage of the National Health Act. So what are the provisions of the National Health Act that are very relevant in the context of organ donation? Now, I mentioned informed consent, and this is very explicit in NHA, particularly Section 48. Section 48 deals specifically with ensuring that consent is obtained from the patient in cases of organ donation. So what is this consent about? Now, the law is very clear that the consent we are talking about is a consent that is informed. Now, informed consent, so it's not enough for, in summary, it's not enough for the medical practitioner to brandish a signed document and say, oh, the patient signed this before we did the removal of the organ and what have you. No, the onus is on the medical practitioner by the provision of that Section 48 to show that the patient was actually duly informed before the consent was signed. Now, let me relate this to the provision of the Code of Medical Ethics. Whereas the NHA, which is the umbrella law, speaks generally about informed consent in organ donation. Now, the Medical and Dental Practitioner Act of 2004, which is the basis for the Code of Medical Ethics, actually shares more light on what are the steps that a medical practitioner is expected to take in ensuring that the benchmark of informed consent is met. So I will take you to Rule 19 of the Code of Medical Ethics. Now, Rule 19 is very clear. It sets the parameters, and summarily, let me just put it this way. The first condition that must be met to ensure that the consent that is obtained from the patient is informed is, first of all, it prescribes a minimum of 3 sessions of counseling for anyone that is to be a donor. In fact, not just the donor, the donee too would also have to be counseled effectively. Now, it dictates specifically that the counseling sessions must be a minimum of 3. Now, not only that, in addition to the requirement for the 3 counseling sessions for both the donors and the donee under Rule 19, it goes further to also prescribe that there must be a time frame between the time when those counseling sessions take place and the time when consent is actually to be given. Now, what does this aim to achieve? The objective here is to ensure that that consent is definitely given by a well-informed person. So it still wants to give you, particularly because it relates to organ donation, and I will soon be talking about revocation. Now, because the law again under Section 57 does not allow you the liberty to revoke a consent that you've given to donate your organ. That is the position of the extant position of the law as I speak today. Section 57 says you cannot revoke after the transplantation has taken place. This can only be done. Of course, you can change your mind. What that means is you can give informed consent today, and while you are waiting for the surgery to take place, you can still take a step back and say, okay, I think I want to take my consent back. I don't want to do this again. I've thought about all of the things they told me in counseling, and I think I want to withdraw my consent. Now back to Rule 19, which I was talking about under the Code of Medical Ethics. It specifically requires that there should be a time lag between the time of counseling and the time within which consent should be given. Now, as I wrap up my thoughts, I've spoken about revocation under Section 57. You are not allowed to revoke. Now, concerning cadaveric donations. Now, what do I mean by cadaveric donations? This is a person making a decision that, okay, once I pass on, I don't want to go with my organs, because these organs can actually be useful for some other person. Our law also makes provisions by which you can do that. You can make cadaveric donations under sections, under provisions of the Act, under Section 55. So now if you are making cadaveric donations, that is, you can have a written document prepared for you, stating that once I pass on, please take out my organs and make sure that these things are not taken to the grave with me to decay. Let someone who needs it be put in a position to use it. But again, there are conditions still related to the issue of consent. Now, the conditions are, first of all, that document must be written, and this should concern us as lawyers, because who can best prepare that kind of document except a lawyer? Now, in addition to that, there are also conditions. Apart from having it written, there should be witnesses, and the law prescribes under Section 55 that you should have at least 2 witnesses that would evidence the fact that this is actually the true intention that you desire to happen once you pass on. So now let me wrap this up as I conclude. I think I have 2 minutes left as I conclude. Now, are there gaps in the provisions of the law? Yes, there are gaps in the provisions of the NHA. There are so many gaps because, first of all, the law makes very general provisions which would ordinarily not be easy to translate into practice. For instance, if we didn't have the CMA coming to spell out the detailed procedures for informed consent. Now, lastly, when we look at the provision of Section 51 of the NHA, it appears as if all the decision making that has to do with organ donation is restricted to the medical institution alone. And what this means is that all the approvals you need to obtain, all the clearances that you need to get would happen within that institution. And we know that that can be very, very dangerous for the patients. Yes, there are some 1 or 2 safeguards in the NHA. It says, for instance, that you must get clearance from the chief medical director. It says the person that is leading the transplant team must not also be the same person that would authorize the transplant process. But if we look at it sincerely, my own concluding thoughts will be that we still need a well spelled out, detailed regulation for transplant processes that would transcend the authorization that is presently provided for under Section 51, that gives the hospitals a whole large range of powers in determining what happens in the transplant processes. Thank you very much for listening to me.
Thank you, Dr. Adejumo. Dr. Adejumo is a lecturer at the Obafemi Awolowo University, and she has discharged the duty for this presentation as any great Ife student or lecturer or alumnus would have done. Now we will go to, we'll take the next presentation from Dr. Yemi Johnson. Dr. Yemi Johnson is Chief Executive Officer of Force Cardiology Consultants, one of our sponsors, and they have a stand. They actually have a stand outside there. I will urge you to visit on your way out of the auditorium, and you know, at least I'm sure you'll be able to undergo a few tests. Don't be afraid that he's a cardiologist. They won't do the surgery there. Now he's going to be speaking to us, and I'd like to ask about the role of the doctors. Dr. Adejumo has spoken about consent. Do the doctors or the surgeons either extracting the organ or transplanting the organ, have any particular role in ensuring these consents were properly obtained at the time obtained? And what other thoughts would you have to share with respect to the legal issues, and also protocols that hospitals, health facilities have set in place to ensure that these procedures are followed? 10 minutes.
Oh, I don't think I'll use up to 10 minutes. Dr. Adejuma has said everything. She knows a lot about this stuff, but I'm not here. Okay. All right, let me just go back a bit. In the US, where a lot of donations are done, transplant surgeries are done, the doctor does not obtain consent. It is done by the organizations that procure the organs. So there are several steps you have to go, but all the doctor does is inform the patient about the procedure, what's supposed to be done, what the complications could be, and things like that. We don't actually obtain the consent, unlike here where it is doctors who obtain the consent, which, like she said, could be dangerous because it's just the hospital using their own rules. There it is a lot more regulated. There's a big organization, kidney transplants, heart transplant, there are different organizations that procure these organs and get the consent, but we don't get the signatures, they get the signatures. That's to, I think, protect us and protect the patient. Now, I've got more questions than answers, because in Nigeria right now, what we do is kidney transplants. That's about the only transplants we do. When it comes to my own specialty, heart transplant, it's a bit different, because most patients don't give consent. They don't, let me explain. When you do a heart transplant, the patient is brain dead. Probably did not plan to be brain dead. And there was no way you could have gotten consent from them before whatever happened. Usually it's a catastrophic illness, like gunshot wound to the head, things like that. So they are never in a position to give consent. And I can never forget the first day I had to perform what we call an angiogram on a brain dead patient. I was a young cardiologist, and they called me out in the middle of the night to do an angiogram on a dead patient, on a brain dead patient. I didn't really understand what it was all about. I got there, I saw about 20 people waiting, all explaining the procedure to me, telling me exactly what I needed to do, and then go and talk to the patient's family and explain what we did and what was going on. But they took care of all the paperwork. And what happens in the US is, on your driving license, you check donor or non-donor. All right, and I can tell you that most black people do not check donor. And that's because they don't trust the system. They might decide to do something to you and use your heart. But you have to get the consent from families. And there it is a little bit more urgent, because you only have a bit of time before the heart is no longer available. So you see yourself trying to explain this procedure and the benefits to a grieving family. I can tell you it is a very difficult situation to find yourself in. But that heart can save somebody's life. And why I'm bringing this up is my next agenda in Nigeria in the next 2 years is to bring cardiac transplantation to Nigeria. And the hardest problem that I think we will face is this consent from a grieving family. Because first of all, you want the donor to be young. You don't want to use an old man's heart like my own. There'll be many, that's a double-use Tokumbo. But you want to use a fresh heart, so to speak. Sorry to speak in such graphic terms, but you want somebody. So how do we go about talking to the family? You know, you're going to need your pastor. You're going to need your imam. I can tell you, legally, I can understand the legalities, but those of us going to be involved in it, it is difficult. In the US, they're more open-minded. They're used to it. They say, yes, you can use my son's heart, that's fine, it will be good. I'm just trying to imagine how I'm going to tell a Yoruba family, for instance, that we would like to use your son's heart. So I have questions. I don't have answers. I have questions. How do we go about this delicate process? Because I know for each culture it's going to be different. For each subculture it's going to be different. Then there's religion. And but I am told by some young people that attitudes are changing and Nigerians are more open to listening to such conversations. I don't know if this is a fact or not. So I have the questions. Now, when it comes to kidney transplant, I know this topic was brought up by the recent happenings. There are two types of transplants. There's live donor and there's cadaveric donor. In Nigeria, it is live donor. The person decides to give you his kidney, usually family or close friend, altruistic purposes. I can tell you, I evaluate these patients from a cardiac perspective before they donate their hearts. And I hate to say, but I can tell you that these people don't really understand what they're getting into. They don't. So they're coming to me after they have signed consent. I think it's about 3 consents they signed. They've signed the first one. They come to me to check the heart, make sure the heart is fine. And I ask them some questions. They don't really understand the process. They don't. So I don't think we're doing a good enough job. They don't understand the process. And you ask them some more questions. You find out that these guys are being paid to give up their kidneys. I don't want to step into too many controversial areas, but I can tell you, you will find an Igbo boy. He will tell you this Yoruba man is his cousin. And he's donating his kidney. And then you ask more questions, you realize that he's being paid. Now, as a doctor, do I go and scatter the whole thing and go and tell them that, look, this man is not his cousin, no, it's not this, it's not that? Then you're caught in that dilemma. His kidney could save somebody's life. I feel, for me, for instance, that's why I disagree with the law. Me, for instance, I'm educated, I'm a doctor. If I want to give my kidney to the chairman of the NBA, who I've never had a discussion with, and he says he's going to pay me $1 million, I don't see why I shouldn't be allowed to do so. That's just one discussion we've had in this business. Many people say, oh no, it has to be altruistic, but what does altruistic really mean? What does it mean if my cousin gives me my the kidney, or somebody I don't know is willing to be paid $1 million? I think if the person understands it, he should be given the opportunity to donate his kidney. I like to bring up these controversial issues too. In the US, we discuss this all the time. Death penalty. People on death row are not allowed to donate their organs. I don't know if we're aware of that. You're not allowed to donate your organs, even though you know you're going to be executed, because I think they might change the sentence halfway, or they might speed up your sentence because they want your heart. But these are things I think we need to talk about. But Nigeria is still using live donors. They are going around now trying to start cadaveric donors. And now, cadaveric donor doesn't mean you go to the mortuary and pick up people's kidneys. It's somebody who just recently died, who has consented. Somebody might have cancer of the liver that hasn't affected his kidneys, and he says, okay, well, I'm going to die, I can donate my kidneys. And like I said, these things are easy to say in theory, but in practical, logistically, it is difficult to have these conversations, especially in our culture. So how we're going to do it, I don't know, but cadaveric donors are about 70% of the business in the US. In Nigeria, it's 0. It will really save a lot of lives as we go about it. So the question I have is, we are going to need guidance into the cultural aspect of this thing, not just the legal. Legal is easy. This is the law. This is what you follow. But how do you convince a parent or a family to use their dying relative's heart? And then in Nigeria, where you can't even tell the patient that you have cancer, you're not likely to survive 6 months. It's difficult to bring up that discussion. In fact, family will tell you, do not tell the patient. We will do it ourselves. So how do you not get consent for that? So these are the questions I have. I don't have much information. It's just questions because this is all a new field for us. The laws are clear, but the laws are also not clear. Thank you.
Thank you, Dr. Johnson, for those posers that you have given us. I'm sure maybe Joyce Esseni will be able to tell us how you can tell a grieving family that their son or daughter should donate an organ or two. Without much ado, maybe before I was born it was a problem, but at least in recent times it's not so much of a problem. But there are protocols that the institutions have when you are donating blood or any other thing. Of course, with organs, it will be even a lot more challenging. And I'm sure that Joyce Esseni, who is speaking next, can share her perspectives on some of those protocols that our health facilities have, whether public or private, as to when there is indeed a willing donor. What are the things that you do? Is it done by doctors, done by nurses? Are they even trained to be able to fill those forms that are meant to be filled? And so, Joyce, you have 10 minutes, please.
Good afternoon. Mr. Chairman, sir, please permit me to recognize the presence of someone special. Navy Commander Felix Udu, retired. In this context, he's my biological father. Daddy, please stand up. He's been a great dad and a good mother since October 2006. It's an honor to have you here, sir. So I'll be talking on this topic, but from the public hospital's perspective. There are a few number of hospitals in Nigeria that perform major organ transplants. Likewise, a very few number of public hospitals in active organ donation and transplantation. By the word active here, I mean that at one point or the other, some public hospitals started organ donation and transplantation and stopped along the way. But a very few of them in Nigeria at least perform 1 or 2 surgeries yearly. In public hospitals in Nigeria, each hospital develops its standard operating procedures for the management of its patients. There is no uniform protocol that binds the hospital. For example, recently, the Nigerian Association of Nephrologists released guidelines on the management of patients with chronic kidney disease and inserted an elaborate section on kidney transplantation. Talking about patients' autonomy consent protocol, Dr. Dami said some things and that she touched on section 48. The hospital complies at all times with informed consent based on the provision of the National Health Act, particularly section 23, for both the donee and the donor. It provides informed consent at all stages because it's a tertiary hospital or a public hospital. They work in team at different stages. They do not do donations for minors. Like minors are not considered for organ donations in the public hospital. In addition to the generic pre-operation form that is printed on the hospital folder, most hospitals still go further to involve their legal unit or legal department, the lawyers there, and they go further to still prepare additional consent form and at the same time an affidavit for voluntary living donation. So they get it drafted and deposed in court. The rationale for this extension is to rule out coercion inducement, to ensure that there's good purpose to save a sick person, that the donor is well informed of the medical risks, the benefits to his understanding, and that he's been examined medically, psychologically, counseled, and certified fit and proper to donate. Particularly, that he's willing to accept and pledges that in the event of any medical eventualities, both pre-operative or post-operative, that he would not recourse to litigation against the donee, the hospital, or members of staff. Actually, the rationale for this procedure or criteria is to ensure that indeed the donation is altruistic. An organ is legally said to be donated when due process is fully complied at all stages, clinical and legal stages, and are met and consent signed accordingly. Why some hospitals insist on biological related donation, like from relative, for example, your parents, your adult child, or your sibling. Some hospitals don't see this as a standard. They accept biological unrelated relative. For example, you have a spouse, you have a good friend, a co-worker, or even a significant other. On a lighter note, a significant other, it has to do with somebody you've established a relationship with, or a sexual relationship with. And I like this part because in Nigerian palace where you have the side chick, is to just say that the side chick is not there just to benefit when the going is good. So the side chick could also consider being a donor if the wife would agree to that. Okay. For public hospitals, compliance with the National Health Act is still at infancy level. They have the ethics committee that go through this, but there's a challenge to that. They also comply with age. The donor must be 18 years and above. The approval must be given by the CMD, the Chief Medical Director, or the Chairman, Medical Advisory Committee, that is the CMAC. They ensure that reasonable reimbursement for reasonable cost is only what the donor is assigned to or encouraged to take. There are so many other things that they ensure that they do, but we have some impediments to this. The desires of doctors under pressure to quickly carry out procedure often render the ethical committee a lame duck. Dr. Dami talked about revocation of consent. That's section 57 of the Act, the National Health Act 2014. If you look closer at the Act, you will see that there's a condition where you can revoke consent. And the law says that it should be done in the same manner consent is given. Now, how is this done? In public hospital, most times, for good reasons, the donor decides to revoke his consent, but they don't do it in the same manner that the consent was given. A true case occurred some time ago. On the day of the surgery, the mother of the donor came to the hospital and insisted that her adult child would not donate. So when you look into the story, we found out that the mother was no longer living with the family, and the donor actually was a step-brother to the donee. So the mother insisted that either the stepmom or the siblings, the step-siblings, should go on to that. And for some good reasons, they need to protect the family, because if you come out, you will find out that indeed it was induced, it was self-induced or some other kind of gratification. It was revoked. They granted the donor's wish because his mom, he understood his mom's request, but they did not go through the same way that consent was given. Altruistic donors are not readily available. The Nigerian factor is one good reason why you can't have true altruism. For example, I may be willing to donate my kidney for a seventh senator or a House member, and I'm jobless. Even if I'm not jobless, for good reasons, I always remember to go to this person for favors, and he will be compelled to assist me, which is not the true altruism. So you have the challenges of life, challenges of emotional blackmail, extortion. There is a wealthy man, a very wealthy man in this profession. For the first time, I was able to understand that somebody's 2 kidneys can fail. And his wife was willing to donate. She was a good match. But he declined. And I wonder why he declined. So while we stepped in, he said he didn't want his wife to emotionally blackmail him, which we know as women, one way or the other, will blackmail our husbands with such gestures. The shortage of organ donors could be associated with social, cultural, and religious belief and myths, such as reincarnation, transplantation of unholy organs. Yes, we're so righteous here that we don't even want to consider somebody we think were better than in the spiritual realm. There's a woman I know, but we know she loved her daughter so well, and she was a good match, but she declined donation. And it was worrisome. We all know that she loved this daughter, but I guess it has to do with the reincarnation. She was not just well informed. So the daughter kept on with kidney dialysis until she passed on. But still, you wouldn't say that the woman is a bad mother. The post-operative complications of the donor. It is expected that after transplantation, the donee will go through routine checkups. But you don't have this provision for the donor, sorry. I'm of the opinion that the Act should accommodate what reasonable reimbursement is and ensure that the donor is accommodated for a very long time, maybe 3 years, so that the donee can still take care of the expenses. Conclusion and recommendation. The law should be reviewed to consider expenses for post-op eventualities, like I just said. There's need for pool organ donation and exchange program. This helps you to know that, yes, if I'm willing to donate for somebody, as long as I'm willing to donate, it doesn't matter who the person is, my organ can be exchanged for somebody else who is a good match. There is need for creation of national transplant waiting list will help us a long way. This could be considered by government. It is a list of registered persons in need of an organ transplant and want to be matched with an organ. Yes, we need that too. There is need to appreciate cadaveric donation in Nigeria. This can be done by advocacy and awareness of cadaveric donation. So far, Doc said there is none in Nigeria. An effective means to achieve this is through advanced directives, will, or codicil. The reason why I would like the law to expand reasonable cost for the donee even after transplantation is because you can't just be benevolent and have a burden upon yourself. Lastly, sharp practice can hardly be carried out in the public hospital because of the multiple stages where donation will be given consent to. In the absence of appeal or clemency, I'm of the opinion that rather wasting the cadaver of a convict of capital punishment or offense, his organ can be of utilitarian value if the government can consider the organs harvested for use in public hospitals. Thank you.
Thank you very much. And on that last note, we have to make an appeal to our governors to carry out executions, because that hasn't happened in many states for many years. But thank you, Joyce Esseni, for your thoughts and your perspective on the subject. Someone told me that Nigeria is a large Tokumbo market, and I wonder why organ donation is a problem, given our mentality of Tokumbo. But this is not Tokumbo, but in similar parlance, I'm sure we will evolve. Now I'm going to call on Otumba Laolu Osoyin, who is the chair of the SLP Committee on Medicine and the Law and treasurer of the section. He is also the vice president of the World Association of Medical Law, and basically we'll be asking you those protocols that have been shared by earlier speakers, is that the global best practice in respect of organ transplant and organ donation? Is there something we are missing? Is there something we can add?
Thank you, Lanet Silk. Good afternoon. I will start by giving a personal experience, just to show how stingy we are as human beings. About 20 years ago, I was a young lawyer then, my father was hospitalized. I was not married. My father needed blood. So myself and my senior brother went to the hematologist, and they said we needed to donate blood. I was a young bachelor, started making little change, slightly sexually reckless. The same with my brother. So we said to the hematologist, do you want them to admit father and sons in the same hospital at the same time? Because we are not willing to donate blood. So we said we would rather pay. And that is the story of the average Nigerian, where we do not donate blood, really. Because we know, for example, that in hospitals you need to actually give them incentives, for people to donate. So we don't really donate. So when we don't donate things like blood, so can imagine organ. Some people will even think that when they get to the afterlife, their bodies might not be complete. So they might not be able to enter heaven since they've donated a body part. But I will give examples from what has happened in other jurisdictions and to see how they've solved this challenge. There is a major thing that happens here regularly, which is blindness. People are effortlessly blind in Nigeria. But in some jurisdictions, there's what is called implied consent, whereby a lot of these people who are blind because their corneas are defective. Some jurisdictions have accepted corneas of corpses to be removed and donated to those who need. All you need is the approval of the medical examiner that the death didn't arise from anything with the cornea, which means it does not affect investigation, it does not affect the coroner's inquest. So they can remove the corneas and they can allow people to see. So imagine how many blind people we have that could have been saved if we just had implied consent on corneas. Now, here as well, we are a country of copy and paste, where we just look at legislations from all anywhere and we just, ship it here without putting considerations to our own social setup, basically. So, donation is illegal. Donation of blood, commercial donation of blood, semen, organs is illegal. But every day, young boys are donating sperms for a fee. Every day, young girls are donating their eggs for IVF. So what have we done? We have essentially created an organized crime whereby people are making serious money by virtue of you criminalizing it. I had a client who paid a young guy for his kidney. A Nigerian doctor certified the guy fit. They got to India. When the Indian doctor examined the donor, my client's kidney was better than that of the donor. But a Nigerian doctor had certified him fit. They had paid part payment. So all we have done in essence is we have just made organized crime. So now we have girls in Nigeria who are donating their eggs for ₦1 million per circle, But if we are patient enough and we look at other jurisdictions, what are they doing? There is the Iranian model. In Iran, it is allowed for you to pay for organs. So, in 2 years, they cleared the waiting list of organ requests in Iran. But they had laws in place putting things in check. Only Iranians can benefit from such. The people who donate their organs are given automatic health insurance. They are paid by the state. There is aftercare treatment, which was one of the problems our senator had in the UK, where he couldn't prove that he had provisions of aftercare for the donor. So in Iran, Iran's kidney program stands apart from other organ donation systems around the world by openly allowing payments of donors. In 1998, Iran legalized living unrelated donor program, which was set up to use emotionally related persons, friends, and well-motivated volunteers as organ donors. This program resulted in complete elimination of the waiting list. The program is regulated and funded by the regional government. A third party will supervise and find donors, but that third party will not partake in selecting who benefits from it, so that they can ensure that there isn't breach or abuse. Government provides essential immunosuppressive drugs to all transplant recipients and donors at greatly subsidized prices. The government and the organ recipients are offered compensation, typically financial incentives. So maybe it is time for us to also consider reviewing our laws here and reviewing and studying further the Iranian model here. Instead of us, as I speak to you now, people are donating organs. As I speak to you now, people are donating sperms, people are donating, but yet we are saying it is a crime, by saying it is illegal. I believe, and my own position is an outright review of the provisions of the National Health Act that criminalizes organ donations, that criminalizes transplantation, for payments of transplantation. And again, at times as well, does the law restrict you taking a kidney from Nigeria for transplantation in the UK? Maybe if that senator had harvested the kidney in Nigeria, frozen it, 6-hour flight, 8-hour flight, taking it to the United Kingdom, maybe we wouldn't have had this problem. So I will end with that question. Thank you for listening.
Thank you, Mr. Osoye. Please, another round of applause for all our speakers. It will be, I know we're pressed for time, but it will be nice to take just two questions. And I would like the panelists to use those to give their last thoughts. So if we have any comment or question in a minute, we will take your comment or your question before we wrap up this session. But clearly from the conversation we have had this afternoon, we are familiar with surrogacy in Nigeria. It's become more accepted than it was a few years before now. And the same process of, as Mr. Osoye has said, eggs are banked, sperms are banked, and at some point someone is hired, usually for money, and those sperms and eggs are fertilized in a third party's womb. And it's still acceptable. I have friends who have traveled from the United States to do their surrogacy here, and they got their surrogate mothers here and took their babies back to the US. And so if we have that and culture has not stopped that from happening, you don't see the child as not your child because another woman birthed the baby. I think we are getting to a stage where we can also break down cultural barriers with respect to the donation of organs themselves. Those are my own thoughts while I wait for a hand up where we can take one comment or one contribution in a minute. Anywhere? Okay, please, can you just give him the microphone, your name, your branch, and in 1 minute, please, 1 minute. Don't give us a story, just ask this side of the hall. There's a gentleman, please rise. And then, who's the second? Let's take a lady, since we're taking just two. Is there a lady? Okay, we have both of them there.
Thank you, Chairman of the section and all the panelists. My name is Mrs. Nena Laduma. I'm from Warri Branch. Mine is the kind of comments. You know, we are all thinking well, but I noticed that what works in other jurisdictions do not really work in Nigeria. I do not know why. Based on what I call, the Nigerian factor. It travails all aspects and all spheres of our life. Now, from the last person, that the panelists that spoke, your thoughts are truly reasonable. But I'm looking at the workability in our Nigerian context. If organ donation and transplant is made a free money venture, you can imagine what will happen on our streets. If you can kill 10 people in a day and sell their organs. So that is a challenge. And I think that's why the law went, restrictive by that National Health Act.
Thank you.
Things are good, but how do we apply it in our present day Nigerian situation? Thank you.
Thank you. The second is, was that the only question? I thought the gentleman behind. Okay. In the absence of any other comments, do I ask the panelists to just do 30 seconds wrap? Dr. Damola, let me start with you.
Okay, thank you very much, Mr. Chairman. My closing thoughts will be, I should attempt a comment on the question by my sister from Warri. I think one of the challenges when we, as researchers, discuss the issue of autonomy in the context of organ donation, one of the challenges is that autonomy can actually is supposed to be double-faced. Let me put it that way. If you're saying I have a right to control my body in terms of me deciding what you want to do to me, then on the flip side of it, we should also be able to extend autonomy to say, if I have 2 kidneys, why can't I make a decision that I want to give out one of those kidneys? It's not going to hurt me, provided I've been certified that it's not going to hurt me in any way. Then even looking at the prevailing conditions in Nigeria, it has been proven that a person can live successfully on 1 kidney. So the second one is supposed to be a spare. So if I'm willing to give up my spare, another way to look at it, using the, do I say double face now? It can be a sword, it can be a shield, like we say. So I can also use it as a sword argument and say, okay, I can trade this kidney and make some more money. But unfortunately, the law remains the law, and the provision of Section 53 remains the law, and I align with my brother that I think we need to start looking at some of these provisions and try to achieve a balance.
Thank you. Thank you very much. There are cars that run or run flat tires, and they don't have spare tire. We'll close, but I'll just take one last comment from Dr. Johnson.
Okay, thank you. Considering I mostly had questions, thank you. But I think what we are going to do in cardiology to preempt this donor problem is we'll start with the artificial heart. And then after we get used to the artificial heart, then we'll bring in organ transplant. So we'll let you people sort out the legal part of it first. Thank you.
Thank you. Please, can you give a round of applause to all our speakers as we round up this session? And we look forward to the next outing of the Medicine and the Law Committee.